Court does call the case. People versus July Allen.
Good afternoon, Your Honor. Raymond Cook for the people.
Ready, Your Honor. Good afternoon, Your Honor. Charlotte Stephan on behalf of Ms. Allen. Your name for the record. Okay.
Yeah, go ahead. All right.
Your Honor, we are in negotiations with the people, and the defense would like to request an adjournment for that purpose. Also, and I apologize, I forgot to bring this to the people's attention ahead of time. I did want to address one of the bond conditions, if the court will allow.
Trying to surprise Mr. Cook. No, it's okay. It's okay. Just well with that.
I think he can handle it, but I'm not trying to surprise him.
Go ahead.
Oh, it's pertaining to the sober link. It's a cost issue for her, and so we are requesting random alcohol testing instead, random ETG alcohol testing instead.
Well, if I had random ETG, she'd have to take one every week randomly. And I'm not clear that her cost. I don't know what the difference in cost would be.
Oh, I understand what you're saying. I think the sober link is $6 a day. Is that right?
Yeah. I think to
well, no. Out how much an ETG test is, if there had to be a confirmation on it. Let's do this. So how much time did you need?
Would 2 weeks be agreeable with the court and the people?
That's fine with me.
Thank you, Your Honor.
Public cause conference will be adjourned to March 26, 2026 at 9. Bond will continue. Mr. Cook, are you going to have a position on that?
I would ask if the court does do random testing be at least twice a week. My reason for asking that is the BAC, from my recollection, is 0.166. I believe there was a crash, and the defendant didn't discharge a firearm during that crash. So I think there's serious safety concerns as it relates to alcohol, and having that in a closer look at the defendant's sobriety and oversight would be a good idea.
So you're suggesting no change?
No change, or the court's going to do random testing at least twice a week.
Twice, 2 times a week. All right.
Your Honor, if I may, I'm not disagreeing with the allegations as reported by Mr. Cook. However, I would note that thus far, she's been compliant with the sober link. There have been no issues. Prior to this incident, she's had no previous issues with alcohol, and she has no drug history at all.
Okay. What I will do with reference to that is momentarily before you leave, what do we have it?
So it's $15 for the additional test, and then the confirmation test, and you just throw it down.
So $6 a day, 42 a week. But to do, and I could think defer to the people. So she did 2 ETGs, gonna be doing 30 a week. Savings of $12. Unless one comes back positive, which she would likely want to have a confirmation test, which is then going to cost her 30.
We'll see if the confirmation test comes
I will come back to that. So there's a matter.
Okay, I see.
Do you want to switch to that?
I think so, yeah.
I'll tell you what I'm going to do. I'm not going to make a change at this point. You're coming back in 2 weeks. Look at it, and then I will make a decision.
Okay.
26.
Thank
Okay.
you, Judge. We appreciate the consideration and the information from your staff.
Thank you. Court does call the case of People versus Jeffrey Thompson.
Michael Gaddy, Assistant Public Defender for Mr. Thompson, Your Honor.
Judicial is granted the other people.
Your Honor, I don't know. Mr. Thompson isn't here. He did have a medical appointment this morning. I was in contact with him yesterday. This is highly unusual for him.
It
It's
is.
my understanding. I don't have any explanation. I would ask the court to indulge us in it and find out about where he is. I know he has court with Your Honor, I believe on the 17th.
I leave it up to the discussion for you.
All right. I just saw him, what was it? It was Tuesday on a housing issue, which I know was causing him a lot of dismay. That got resolved, as I remember,
Actually, on the 17th,
for
entry of an
right. Right. So he did tell me that he had some medical something, which is not surprising. And if it's medical regarding to his medications that are necessary for him to make it day to day, I can understand. I'd rather him be there than here. I'll be honest with you, if that's the case. I don't know if that's entirely it. Can counsel approach with the head of bench conference, probable cause conference in this matter, March 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Already signed? Wow. Clerk call the case, people versus Lucretia Hunter. Yeah, what Fishing was honking.
Yeah, Kevin Bosky, repeat.
Good afternoon, Your Honor. Michael Vincent on behalf of Ms. Hunter. State your name for the court.
Shatter.
Your Honor, we need an adjournment. With your permission, we need the BP gas station cameras where this incident allegedly took place. I know I'm here.
Are they mine? What do you mean you need? Oh, wait. Okay, so you need an adjournment.
Yes.
And you want the BP camera.
Yep.
I just said, okay, will that work? I can get you the adjournment. Is there a problem with the?
We'll look into it and see what we can come up with.
Okay. Is it the one up here?
One by La Forge. Here in River Drive.
Okay. So it basically you're requesting some time to check into whether or not the third
See the
party.
prosecutor.
And that.
It's right at the corner of Ann Street, here in River Drive, La Forge, that whole area there.
Okay.
Back on the request, I'll follow up on it.
Okay. Very good. Oh, you don't have anybody here with you, do you?
Yes, in spirit, I do.
Okay. How do we? No, anyway.
Know the good dates and the bad dates.
Is that a list?
As long as you go more than 1 week.
As long as they go more than 1 week?
Yes, sir.
Okay.
So,
Then April 2nd, I hear you're available.
thank you, Your Honor.
Thank you.
Time?
Oh, I said it at 9 and then
Okay.
the time, and you're not going to pay attention to that anyway because you don't know how to open email. Staff will get it and they'll tell you when you got to go.
You're right again.
I know. Thank you.
Have a good day.
You do the same. Court calls the case, People versus Rebecca Dooley.
Ready, Your Honor. Your Honor, thank you.
Reflecting at a bench conference in 7th during in this matter. So you can look at some things to April 16th, 2026, 9 a.m. or as your invite indicates.
Thank you, Your Honor.
All right, thank you. Client like North Carolina better than Michigan?
Well, that's going to be a setup question for her because she's going to say that's been a big part of her recovery.
Is it?
And for that reason, she would say that, but
Oh,
I don't think she understands the import of the court's actual question.
all right. Thank you, ma'am. Bond will continue. Uh-oh. I can't hear her, but she can, oh,
Rebecca, unmute again. There you
Okay,
go.
can you hear me?
yes, we can hear you. Okay. So you got the date and we'll see you then.
Okay, thank you, Your Honor.
Thank you, ma'am.
Thank you.
Thank you, sir.
I missed the whole thing. I stated my
Oh.
name. He's like,
Oh, no, I want to hear what she said. Missed the whole thing. Yeah, that was your client's hearing. She missed the whole thing, but I think what she missed was the bench conference because she was closed out. So I think that was what she was thinking. Go ahead.
Good afternoon, Your Honor. Joseph Hall, appearing for and on behalf of Mr. McClure, who stands to my right.
Michael McClure.
Thank you, Jim.
Thank you.
Where's Vincent?
I got him out of here as soon as I could. I mean, one of us, Judge, one of us in the room at one time is enough.
Again, he sent Vincent out. Vincent's lost. I had to get through your hearing. I have to go find him. All right.
I've done worse on a day. Your Honor, in this case, I believe Mr. Chebalowski just sent me what was a transcript for a dispatch recording that I don't even believe is going to be relevant to this case overall, but I believe that completes discovery, and we would ask this court to set a preliminary examination.
All right. And would the people have their witnesses available on the 24th? All right. Preliminary examination in person will be set March 24th, 2026, 9 a.m. before judge for me.
Perfect date, Judge, as always.
Okay. All right.
Take care, Your Honor. See you later.
Go find him. Drive himself.
I'll do my best.
Drive himself.
Yeah. I'm more trusting than Amanda Nelly.
That'd be like parking lot of bumper cars. Get out there and find him.
That's why you park in the back, right, Judge?
Hurry up. Court calls the case, People versus Lisa Keebler.
Al Kavalowski for people.
Good afternoon, Your Honor.
After.
John Shea appearing on behalf of Lisa Keebler. Will you state your name for the record, please?
Lisa Keebler.
All right.
Your Honor, Mr. Chebalowski and I recently had some discussions about this case, and I believe I am not misstating anything by saying we would like another 3 or 4 weeks to continue those discussions with an aim toward resolve.
9th or 16th?
9th, Your Honor.
Thanks. During this matter to April 9th, 2026, 9 a.m.
Very good.
Or as your invite indicates.
I'm sorry.
I said 9 a.m. or as your invite indicates.
Got it. Thank you.
How to open email, so I know you'll find it. All right.
I open my own emails.
Unlike that.
Yeah. All right. Thank you, Judge.
All right, then. Bond will continue. Court calls case People versus Andrew Lemmy.
Good afternoon, Your Honor. Raymond. Morning, Judge.
Alan Daniels on behalf of Mr. Leamy, who stands to my right.
Your name, sir?
Andrew Leamy. Judge, today's date and time set for a probable cause conference. I have had a chance to speak to the prosecutor. We are still missing all digital discovery. My understanding is there's a significant amount.
It all?
Yeah, we don't have any of it yet. My understanding is that we're going to be getting it shortly, hopefully today or tomorrow. So we're just asking for an adjournment of the probable cause conference.
Okay.
It's been marked for discovery. That's all been sent. It just needs to get sent to defense counsel. I anticipate that being done either today or tomorrow.
April 2nd. Will that work?
We were looking at April 9th just because of my schedule, Judge.
Am I supposed to care about your schedule?
If possible, April 9th, Judge.
April 9th, 2009 a.m.
Thank you, Judge.
All right, bond continue.
Thank you. Thank you. Have a good day, Your Honor.
Court calls the case People versus Latasha Rogers.
Good afternoon, Your Honor. Raymond. And Your Honor, Ms. Rogers is on Zoom.
She is.
Okay, excellent.
Rogers, can you state your name, please?
Latasha Rogers.
Thank you. For the record, Your Honor, PA 1222 for attorney for Ms. Rogers.
Right. And so you're looking Has she been accepted to sobriety court, or are we
My
still
understanding
looking?
of where we stand is she has been screened by Statman. The referral for sobriety court still needs to get completed and sent to the sobriety court to see if they'll accept her.
Yes. And Your Honor, I can expand for the court's understanding a little bit further on that.
Okay.
I've had a tremendous number of discussions with Ms. Pilara, Mr. Heaton, and now with the 14B district court. I think initially our understanding was we were trying to keep her within the 14As. But after discussing further with Mr. Heaton, I think the understanding is now that sending this back to 14B, which is the original court where the case is assigned to.
Right.
However, I understand we still need to do this as a transfer. So I just spoke with the probation officer. Unfortunately, I only have his first name, Brett, from 14B. He had, we've got a number of these steps already completed. As Brother Counsel indicated, she has been screened by Mr. Statman. And actually, to Ms. Rogers' credit, Mr. Statman had recommended that she commence the Dawn Farm Support Group outpatient counseling, for which she has done. She just met with them and the AA requirements this past Tuesday. And so she's taken some very significant steps rehabilitation-wise and with her screening. I just need to get from 14B to MOU to then provide to you to sign, send back. So we're asking for a brief adjournment for administrative or logistic purposes.
All right. What? We want to get her moving as soon as we can. I've been adjourning most of those to the 2nd.
April 2nd?
Yeah, that will work.
If I may check briefly, Your Honor. If that, actually, I know offhand, if that would be in the afternoon as we have been, I'm available. I only have something in the morning that day.
Okay. All right. April 2nd, 2026, 9 a.m. both. You'll
To be. Excellent. Thank you, Your Honor.
Thank you, ma'am.
Thank you.
Court calls the case of the People versus Jeremy Shue.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Shue, who is
there.
coming right over.
I was expecting to see him on.
Introduce yourself.
Jeremy Shue.
I know Mr. Shue.
Thank you.
Had our moment. All right.
Denied the Zoom hearing.
Yeah, all good and getting better, Your Honor. Mr. Shue is here in person. I wanted to ask the court to consider a motion to stay. We're in the same holding pattern that we have been. He has a pro per interlocutory appeal on a companion case, and that companion case involves the same series of episodes and the same car stop that is the subject of his interlocutory appeal. Last time we were here, Your Honor continued it rather than staying it just to see what would continue to happen in the Court of Appeals. What has happened is they dismissed on administrative grounds. Mr. Shue filed a successful motion for reconsideration. They've now, because it was just an administrative dismissal, it never got to the merits. They've now reopened it, and it's continues to be on a leave application.
Okay.
And rather than come back every few weeks, we're asking
so I guess I'm a bit confused. I'm a bit, I won't say confused, but want to make sure I have an understanding of how the decision in that appeal affects this case.
Sure. So there are a series of alleged episodes that took place in a neighborhood, some items that were allegedly taken. And the first case is a misdemeanor case in Judge Washington's courtroom involving the first set of items that were potentially recovered in a car stop, or at least items that might look like those items. This arrest came many months later, involving another house in that same neighborhood in that same period of time, and also involving things that were found in that car stop. So if that is a bad car stop, then that impacts this case as well.
I see. So it's really, I see what you're saying. Do the people have a position?
We'll leave it up to discretion of the court.
Pardon?
I would leave it up to discretion of the court on objection.
Hold up. This is where things get legally intense. What the defense is trying to do here is called a stay, basically hitting pause on this case. But not just for convenience. This is a strategic move. Why? Because there's another case, an appeal, that could completely change what happens here. Now think about this. If that earlier case proves the police made a mistake, like an illegal car stop, then everything tied to that stop could collapse. Evidence? Gone. Charges? Weak. So the real question is this a smart delay or a desperate gamble? Because if that appeal fails, this case comes back stronger than ever.
So my other issue with granting a stay, which is, I mean, I get why you would want that to happen, but are you asking, in essence, for an order similar to that was signed by Judge Washington?
That's right, an identical order, and I'll keep the court up to speed as things develop in the Court of Appeals.
All right.
She set a status date for a few weeks from now.
Status date for March 26th, but I wouldn't do that. And how, I'm just thinking timing wise, I'm not sure how fast or slow the Court of Appeals is operating at this point.
Yeah, I mean, I have to be honest, I'm really surprised that it's taken this long, but and I may have been because of the initial administrative denial, but it doesn't seem to be moving anytime soon on this.
All right, what I'll do is I'll order it stayed with the next court date being, I'll just go a month out from there, April 23rd. (2026) for status. And then I'll just adjourn. Well, the way we'll have to do it here, since it's not my misdemeanor or my district court docket technically, is I'll have to give the probable cause conference that date. Okay. Effectively kind of a stay, but
no, that works, Your Honor, and I'll be in touch with your staff and with Assistant Prosecutor Childers as their developments and in advance of that date, if it's still in limbo.
Yeah, if it's still in limbo, and so that I'll state this on the record, my staff will remember this. If we still don't have a resolution, now that I can appreciate what you're saying in terms of the case itself, I'm not going to have a problem adjourning it by stipulation.
Okay.
Say a month out, so we can see where we are.
Great. Thank you, Your Honor.
All right. Thank you.
Next time.
Court calls the case, People versus Joseph Smith.
Oh, man. David Chan, we have a Joseph Smith, Your Honor. Please state your name for the record, Joe. Joseph Smith.
All right. I think I may have a plea form.
Correct, Your Honor.
And that would dismiss that one. Okay. So the plea form indicates that he's going to plead to count 2 of use of a controlled substance, that being cocaine, the 1-year offense. Upon a successful plea to that charge, or count 2, count 1 would be dismissed. And so I'm also clear, this is taking place in the case 1915.
Correct.
And then upon a successful plea in that, to that count 2 in that case, count 1 would be dismissed in that case, as well as there would be a dismissal of 25 FB 1343 FY. And that is the entirety of the court's understanding.
Yeah, I believe we're going to file a NOLO. Go ahead.
Yeah, I would file a knowledge on the source. It's on entry the plea, although my virus.
Okay.
But yeah, that's what we're doing today.
All right. May I have him sworn?
Raise your right hand.
Now the energy shifts completely. This isn't about arguments anymore. This is about a plea deal, and everything is moving fast. Let's break it down. The defendant agrees to plead guilty to a lesser charge. In this case, cocaine use, and in exchange, other charges get dropped. Sounds simple, right? But this is one of the most critical moments in any criminal case. Because once that plea is entered, there's no trial, no jury, no second chance. And here's something most people miss. The judge is carefully making sure this plea is voluntary and informed. Every question you hear, it's about protecting the record and preventing future appeals.
I swear and affirm the testimony I'm about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Joseph Smith.
All right, Mr. Smith, it's this court's understanding that you're going to plead guilty to the charge of use of cocaine. Is that your understanding?
Yes. Yes.
That's a misdemeanor, punishable by up to 1 year, $2,000 fine plus court costs. You understand that, sir?
Yes.
All right. And understanding that, you still wish to plead guilty, right?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation or parole at the time of this offense? No. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
I am.
And because you believe that you're guilty of this offense?
No.
Well, for whatever reason, they don't have my information out, but that's okay. I can find it this way. Sir, on the date February 3rd, 2025, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Do you know what you were using was cocaine?
I did.
Okay. Sir, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
I do understand it.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None by the defense, Your Honor.
And have I complied with the court?
And just like that, it's done. The plea is accepted, charges are dismissed, and the case moves straight into sentencing phase. No dramatic ending, no courtroom explosion, just finality. But don't mistake the calm for simplicity. This is how the system works most of the time. Quiet decisions with massive consequences. Now the focus shifts to sentencing, where the real outcome will be decided. Will there be leniency or consequences that hit hard? Stick around, because what happens next could change everything for this defendant.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be April 8th, 2026, 9 a.m. That's before me. And also 25 FB 1343 is word dismissed. Signs off on that. Okay.
Perfect.
Bond continued. Thank you.
Thank you, Your Honor.
Thank you, sir. On your way out, my probation department is on the left-hand side down there. Just stop in there and start the sentencing process. Okay?
Yes, I will.
Thank you. Thank you, Mr. Champ.
April 8th. And
Court calls case People versus Demetrius Caldwell.
Jablowski.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Caldwell. Your Honor, Mr. Caldwell is in the Washtenaw County Jail. Your Honor, we're just seeking an adjournment. This was scheduled today for a competency hearing. I have not received a report as of yet, but I did have correspondence with the doctor who was doing that interview Monday of this week. So I think that is coming sooner rather than later.
Got it. They didn't say when he would have the report. They just said when the appointment was, right?
Correct.
Okay.
Dr. Oliver didn't give me any indication, just that, I was glad to have heard from her in the first place because that lets me know that, he's either spoken with him or was going to be speaking with him relatively soon.
I'll adjourn it to April 16th, 2026 at 9 a.m. for a competency hearing. If we get the report prior to that point, we can move up to date.
Perfect. Thank you so much, Judge.
Yep,
Thanks. Judge, that's it for me today. I've been on every docket with you today.
Absolutely. I was going to say, we're going to miss you because right now, right? All right. Take care of yourself.
You too, Judge. Bye.
Bye-bye. Yeah, he's down. That's what they said.
Yeah, I'll double check. I wasn't aware of that.
Court calls case, People versus DeMarco Henderson.
Good afternoon, Your Honor. Christina Saxon for DeMarco Henderson. Mr. Henderson, please unmute and state your name.
DeMarco Henderson.
Thank you. All right, what are we doing?
Your Honor, I need to request an adjournment. There are two people involved that I need to speak to with the hopes of resolving this short of trial.
All right. Well, April 2nd give you enough time to get that accomplished?
Yes, Your Honor. Thank you.
All right. Probable cause conference, April 2nd, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you.